I think in film, everybody's always vying for power and control. He was one of the few directors I've worked for that was very kind and respectful. In my opinion, I find it very hard to believe the allegations against him. I feel like maybe Blake smelled his kindness, mistook it for weakness, and tried to take advantage and take power. So
you believe Blake Lively wrestled control of the film?
I think she tried to, yes.
Did she succeed in the end?
Probably, yeah.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. Last week, I let you guys know that Judge Lehman denied an extension for discovery and denied a extension for an amended complaint. And that got me thinking about the case as a whole and doing a little bit more digging into the situation. There was a bunch of filings that happened last week with Stephanie Jones. There's been this conspiracy going on around about this elusive subpoena and a lot of chatter that's been happening online related to the case. And ultimately, we're in this place right now with this case where the motions to dismiss have all been fully pled. And now we have to wait and the judge has to decide his ruling. And in federal court, that can be months. There are some guidelines in civil court as terms of like when a judge needs to respond, but there's a federal rule that states that a judge has to either rule on or make a note on a case that's pending a motion to dismiss within 6 months. To give you some insight, Judge Lehman was dealing with a case where a motion to dismiss was filed last March, and he didn't rule on it until November of this year. While this case is expected to go quicker, this is a judge that has a very packed schedule and is dealing with very serious issues in the state of New York, dealing in the Southern District of New York with a diversity jurisdiction case that involves him having to get his feet wet in California law that he doesn't specialize in. There are a lot of complications in this case. There are very polarizing positions on both sides. And when I'm trying to even do my own reporting, unless I'm completely pro Justin, if I even try to share like the opposing side, sometimes I feel like I can't without getting a lot of backlash. And in this environment, it's still a case that's in court. It hasn't been ruled on by a judge. It also hasn't been seen by a jury. I have been on the receiving end of an abusive lawsuit, many in my day. And the lawsuit complaints have made a lot of allegations against me that were not true and were not provable to be true. And the cases were either dismissed or settled with absolutely no liability found on my part, even though these complaints said I had been participating in really despicable activities. So I'm very keenly aware that both sides could be using these complaints as a way to get back at each other, right? They can use litigation privilege to make really serious allegations against one another under the guise of litigation privilege, which gives them a shield from defamation. So anything that they put in their court records, they can say without Justin being able to sue Blake or Blake being able to sue Justin. And this is the biggest problem for Justin when it comes to his case with the New York Times and Blake Lively. One of the issues that I know is going to be the hardest for him is the litigation privilege. And it's going to be the privilege of her reporting sexual harassment. Whether we believe it's sexual harassment or not isn't really for us to decide. We are the public, we're not the court. And when it comes to the law with sexual harassment claims and workplace discrimination, employers can defend themselves, but they also have to adhere to the guidelines of both the state in which their contracts are in or where they're located and federal guidelines around gender and sex-based discrimination. And women are afforded protection under the civil rights laws that were enacted in the 1960s under Title VII. Okay. And so Justin has a duty as an employer to adhere to the law. For Blake to be able to prevail on this claim, she's going to have to prove that what happened to her was either so severe or pervasive, meaning it was a huge global issue within the workplace that caused such a hostile work environment that it changed her ability to do her job and caused her damages. And as far as what Justin is doing, is he is in a way trying to kind of flip the narrative and say, yes, she worked for us, but she was really the one that was in power. And thus, these allegations were used to gain power. And he denies that these situations happened. He has firmly denied that. Okay. Firmly denied. And she says that it happened. He says it didn't. There are so many disputed facts in this case, they agree on nothing. Zero. Zilch. And so the motions to dismiss are out, right? And we're waiting for them for a judge to rule. And like I said last week, I'm pretty confident that the New York Times case is going to be dismissed. I also think that the defamation claims that they have against Blake Lively are very vulnerable to dismissal too, because as much as we don't like the litigation privilege, Blake Lively's allegations about the sexual harassment are in a complaint that was filed via a CRD document in the state of California, which is a legal document. And her team was very smart about how they released the information. Now, Justin is obviously arguing that they bypassed the litigation privilege by giving the information to the New York Times. The judge is going to have to rule on what their decision is on that. But in the meantime, there's another ongoing battle on the Stephanie Jones side of the house when it relates to a subpoena. And there's been this huge conspiracy happening on social media about where the subpoena came from. And then today, according to the Daily Mail, the subpoena was signed by Blake Lively and Ryan Reynolds' attorneys in the state of New York. And it was filed in the New York Supreme Court, but they couldn't reference a case number. And there was no stamp on the court record on the subpoena. So this subpoena issue is probably not going to be a very big issue when it comes to Blake's case, because whether or not she obtained them through a legal subpoena or not, she can still subpoena the records now that she has an active case. And so it can be fixed by an actual subpoena for the records. She can get the actual texts from the people involved. However, the subpoena is an issue when it comes to the Stephanie Jones case because there's a discrepancy on the confidentiality agreement that she had with Wayfair and whether or not she was allowed to give the information to Blake Lively and Leslie Sloan and the date and the timeline of when she received these messages. Right now, there's a lot of misinformation out there because we seriously don't know about the subpoena. We don't know when it was issued. We don't know anything more than what Justin's side is saying about what happened and what Blake's side is saying what happened. And neither side has the same story. So today, Brian Friedman spoke to the Daily Mail and he claims that Jones only passed to Stephanie, only passed him on to Leslie Sloan and Blake Lively out of spite. And he said, there is no doubt that Stephanie Jones willingly and maliciously spread private and confidential communications concerning her former clients in an effort to humiliate them and destroy the fledgling business and reputation of her former employee. She did so purely out of spite and prior to any phantom subpoena that we have yet to see. What is interesting is that Miss Jones claims that she got these records from subpoena, but then in court, she didn't file it as an exhibit in her motion to dismiss, nor did she file it as an exhibit in her lawsuit against Justin. And if the subpoena was there, I mean, why can't we just put it in the court record? What is going on with the subpoena that you can't attach it as an exhibit? And then why is the subpoena being given to the Daily Mail, to Deadline, and to the New York Post, and not one person is sharing a photograph of what the subpoena looks like? That's really abnormal, quite honestly. If the subpoena is legitimate, they should just share it. But instead of giving it to the court, Stephanie gave it to the tabloids, which is very strange to me. And then none of them are showing it. According to Friedman, a subpoena requires a case number from a filed legal case to be referenced, and no case was ever filed against Jones or anyone prior to her giving Blake those text messages. And Miss Jones's attorney, said more distractions and still no defense for what the whole world saw in those text messages. If Mr. Baldoni and his attorneys believe the subpoena legally requiring Miss Jones to turn over the damning evidence demonstrating his clients orchestrated a smear campaign against Miss Lively is fake, he should sign an affidavit saying so, and we will look forward to the discovery process. They're basically implying that he's lying to the public and that he is doing this to smoke and mirrors. It is odd, though, that Justin's side hasn't seen this subpoena. Jones' argument in her motion to dismiss is that she's complied with the subpoena when she turned over the messages to Lively that ended up being central to her lawsuit against her co-star in December. But Freeman said he has not seen the document and questioned whether it was ever filed, while noting inconsistencies in the timeline. And then the Daily Mail says they reviewed the copy of the purported subpoena dated October 1st, 2024. It says it was filed in Manhattan Supreme Court, but it has no court stamp on it. It is signed by an attorney working for the New York law firm Manette, Phelps, and Phillips, who represent Lively and her husband, actor Ryan Reynolds. In order for Jones to hand over all the documents and communications concerning Lively and Reynolds and their companies, that's what it was asking for. So, under the New York law, it does state that in order to get access to these kinds of records, you have to have an active case. And there's no case that anyone can find in New York Supreme Court. And it sounds like it's the Supreme Court, like it's the Supreme Court, but it's their highest level of civil court is called Supreme, so it's not the actual like New York Supreme Court, if that makes sense. I don't know if it makes sense, but that's what I've learned about New York. So it's basically like they handle the most significant civil cases, but it's not like the Supreme Court that you would go to have an appeal overturned. So the subpoena issue fight is about, did she disclose information to Blake Lively without a subpoena, which is a part of his contract? And then was it provided to her before a subpoena? And did she violate the confidentiality guidelines of this agreement that she had with Wayfair? And it's going to be a mess, very messy here. Wayfair and Friedman are really focusing on the timeline and whether or not she gave this information before she had a subpoena. And then they're also trying to question if the subpoena was valid. And a lot of this is honestly just, we don't know until the court happens to see this. And we don't know if both teams, both sides are lying. Like, we don't know if the attorneys on both sides are just blowing us smoke, right? We want to assume they're being honest, but they're also out there defending their clients. So you have to take things kind of with a grain of salt. Now, she's going to claim that everything was given by subpoena. And she also references that there's this law, and I don't know if it's going to hold any weight here, but she says that it's a Speak Out Act. So Wayfair's counterclaims attempt to wield the confidentiality provision of the services agreement between JonesWorks and Wayfair to suppress disclosures concerning Lively's harassment at the hands of Wayfair's co-founder, as well as the company's own rule in the ensuing retaliation campaign, while punishing Jones and JonesWorks for cooperating with a legal process that brought those facts to light. This effort is squarely prohibited by the Federal Speak Out Act, which prohibits the enforcement of pre-dispute non-disclosure clauses in matters involving sexual harassment and retaliation, and accordingly renders the confidentiality clause of the Wayfair agreement unenforceable. They say the irony is thick. Wayfair does not deny the public scrutiny of Baldoni due to his mistreatment of women. The ensuing smear campaign against Lively in the wake of such mistreatment and the public reporting of the smear campaign and its genesis, it does not take issue with Baldoni's gross mistreatment of Lively. Instead, Wayfair cries foul that the campaign came to light and seeks to punish and retaliate against Jones and JonesWorks for compelled disclosures. This effort to chill disclosure, shift blame, and distance itself from its own conduct and its own founders' blatant harassment is offensive. Okay, so I know a lot of people are really upset that anyone under these laws can make a claim and it can be protected, but the laws exist for victims, okay? And most people don't lie when they come forth with claims. And the challenge here in this case is that if Blake Lively perceives she was sexually harassed, that's her perception. Even if we don't believe what she thinks is sexual harassment, okay? Even if she claims that someone looking her in the eye is sexual harassment, or even if she claims that Mr. Baldoni tried to add sex content that she didn't agree to, or there wasn't an intimacy coordinator, and even if there's disputed facts, right now, she still has the claim that it exists. And she can perceive it as sexual harassment, but it still not be sexual harassment under the law and where Wayfair would be found liable. It's like completely skewed in that way. With that said, there are some things that are questionable in what Baldoni and his team did because of the implication of what she was making allegations about. And I know that his supporters and people that support him will say, well, they knew it was false. They knew she was just leveraging this to get what she wanted. So they're looking at this as it was all fake to get power. And I totally get that. But even so, some of the text messages that did come out that could be problematic for them have to do with them joking about her calling him a sexual predator, joking about the lingering kisses, and sort of making light of the things that she complained about. Part of the problem for me in this situation is that under the law, instead of hiring a crisis PR team to manage the crisis that he found himself in, what Baldoni probably should have done was consulted a lawyer. And instead of having a team manage the online chatter and defend himself, which I understand everyone wants to defend themselves in the media, and he's going up against a huge star who has a lot more visibility than he does and more power in Hollywood. I totally understand that. But I don't think that some of the advice that these PR teams gave him were good. I don't think there should have been any discussion about speaking about the situation, period, when it came to the claims of sexual harassment. I don't think that shifting the focus to Ryan would have been a good thing. I don't think shifting the focus to Blake. And again, they say that none of this was implemented, right? So they denied this happened. And because Blake Lively's case is so heavily focused on the smear campaign and the damages are linked to the smear campaign, what she's really doing with this lawsuit isn't necessarily about sexual harassment, it's about the retaliation. The retaliation component is probably the weakest part of her case because thus far she hasn't put out evidence to prove that it happened. It doesn't mean that some of the text messages weren't shady. I mean, some of the things they said are not very nice, even if you don't like Blake Lively, right? They're probably frustrated. It's a high stress situation. I get it. But the sexual harassment claims that she brought were remedied by the 17-point agreement. And she claimed that after the fact of that agreement, everything on the set was fine. So, really, the fight will become and the damages will be related to not the sexual harassment, in my opinion, but to the smear campaign. And the New York Times article was heavily focused on that smear campaign. The problem with this retaliation situation is that there was a huge problem with this film before it was ever released. And people that followed this from the beginning of when he acquired the rights of the book to when they started the filming process and they worked on the script and all of those steps, they know that the backlash had been starting for months against Blake, almost a year, 2 years. The minute she was cast, there was backlash. And recently, Colleen was in her Facebook group, and I took some screenshots and I want to share them with you because what she shared in here, I think, isn't going to be good for Blake because Colleen's history of poor marketing and monetization of domestic violence had already led to her cancellation. She has nail polish that she's designed around It Ends With Us, which is so weird. And then she did the adult coloring book, which actually resulted in the publisher having to drop the book because people respond to it so poorly. They thought it was disgusting of her to try to capitalize on a film and a story about domestic violence and turn it into a monetization of coloring products and like promotion of outside products outside of the film or outside of the book. So it's no different than Colleen promoting her book, her coloring book, and her nail polish that got her very serious backlash. as it is Blake getting backlash for promoting the alcohol and the hair care line because of the fans. But Colleen was on her public Facebook, and someone left this comment talking about a new book adaptation that's going to become a film. They said, I was so excited for Justin to direct It Ends With Us, but couldn't picture him as Ryle. Out of the whole cast, he was my favorite in his part, along with young Lily and Atlas. Colleen responded and said, I think they all had a lot of backlash in the beginning because they were aged up and people were skeptical. But I think they did wonderful in their roles. Jenny Slate is my queen. So she admits that there was a lot of backlash because of the choice they made to age up the characters, which is why fans didn't like her wardrobe and they thought she looked frumpy and old because she's 15 years older than the Lily in the book. And another comment said, as much as I loved the book, I unfortunately can't get excited for this because of all of the changes done for the worse and It Ends With Us. And Colleen says, well, I didn't write or cast that one, but this one is under my production company. So hopefully you'll love the final product. So now she's trying to say she didn't write it or cast it, even though she was part of the writing process. She's listed as a writer, and she and Justin have video of them showing the script and to fans. And she did help with casting. She's trying to distance herself from all of the problems that happened in this film. She's admitting that they created the backlash by aging up the characters. There was problems with the script, okay? And then this is another and then for her to say Jenny Slate is her queen, she's distancing herself from Blake. She did an update on March 19th, and she said, I will admit December and January were very dark months for me for a lot of reasons, but also just seeing how I can never ever trust anything posted by the media or even influencers as has been disappointing and a lot to accept, but also just having to be quiet about it because there's no right way to defend yourself or your decisions or your involvement or lack thereof put me in such a weird and lonely headspace. So she's trying to claim that she had no control of the film, even though she's on, interviews with Blake saying she's in the editing bay, she's on set of the film. She was in part of the casting. She was part of the screenplay writing. She did rewrites of the script with Justin and Christy. It's odd for her to try to distance herself from all of it now because she still has to keep promoting her new films. And I think the key moving forward is if any of these other films have issues and if there's backlash and if the film sets are chaotic, Colleen Hoover has to be looked at as a suspect. But her own fans started the backlash because of her decision to age up the characters at her own admission. So how then does Blake say Justin caused the backlash? In a way, I guess, because he and his scriptwriter decided to age up the characters, but then she made changes to the script that also made people upset. There's no perfect way to say this, but the book was a disaster. The film was a disaster, and the film adaptation was a disaster waiting to happen because of the backlash Colleen got and fans were giving her the entirety of the filming process. They made a lot of mistakes and fans were not on board with it. So is Blake going to subpoena all of the friends and, the fans? What role did the fans play in this and how did Justin cause the fans to have that reaction? They had been having that same reaction about Colleen doing the same crap. And Colleen even admits she started the backlash. So the smear campaign to me is very easy for me to say, I don't believe it. I don't believe the smear campaign at all. I think the claims he has for the takeover of the movie are kind of separate from the sexual harassment. And if he can prove it, I hope he gets the damages that he needs. I don't believe that he sexually harassed her. But again, a court has to decide whether or not it was pervasive enough, hostile enough, and whether or not it caused damages to her, which are going to be extremely hard for her to prove. Her decision to launch her hair care line, and she claims that his smear campaign damaged her hair care line, but she was the one that decided to launch the hair care line during the film premiere. So is it his fault or is it her fault? Right? I'm just saying. This is not an easy case. I hate the implication that this case could harm other victims, right? I hate the implication that laws being used to protect victims are being exploited and manipulated by wealthy people that these laws shouldn't be protecting because what she endured isn't what most people endure, right? But that uncomfortableness about how protections that were made in California to help victims are now being questioned as constitutional, and whether or not like these laws should even be in place, that makes my stomach fall because there's people in California that can't afford lawyers, that can't afford to fight, and that these laws would help. So if Blake is exploiting that law for her own gain, that makes me mad. Equally, it makes me mad that there could be a possibility that this law that was put into place to help victims could be in jeopardy and overturned if they go to Supreme Court. Because I'm obviously supportive of victims, and most victims are not wealthy like Blake Lively. So, what are your thoughts about all these developments? About the subpoena issue with Stephanie, about the smear campaign stuff, the Blake Lively stuff, and the Colleen Hoover stuff? What do you think? Tell me in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.